You're stopped at a red light on Jericho Turnpike at Route 110 in Huntington, waiting to make your left when a pickup truck runs the light and slams into your front door. You didn't roll through anything. You didn't speed. 3 days later, the insurance adjuster calls and tells you something that stops you cold. Their review shows you were 30% at fault. You figure that's the end of it, that you can't sue for anything. That is exactly what insurance companies are counting on you to believe. And this year, there's a brand new number both sides are fighting over, 50%. Here's the question I get more than almost any other, and it usually comes from someone who's already talked themselves out of calling a lawyer. They say, the accident wasn't entirely his fault, so can I even sue? Or worse, they say, the insurance company says I was partly to blame, so I guess there's nothing I could do. In New York, that thinking is wrong. And it has been wrong for a long time, but the rules just changed in a way that makes understanding this more important than ever. New York has always used what's called comparative negligence. That means fault in a car accident doesn't have to be all or nothing. If you're in a crash where you were partly responsible, that doesn't automatically kill your claim. It never has. What changes is how much you could recover. Until this past May, New York used pure comparative negligence for every kind of case, including car accidents. Under that system, even if you were found 90% at fault, you could still recover 10% of your damages. It wasn't common, but the math worked that way. Fault reduced your recovery. It never eliminated it, no matter how lopsided the percentages were. That changed on May 27th of this year. New York passed a reform that added a new rule specifically for motor vehicle cases under CPLR Section 1411B. It doesn't touch slip and falls. It doesn't touch medical malpractice, and it doesn't touch premises cases. It applies specifically to car, motorcycle, and truck accident claims under Insurance Law Article 51. And here's what it says. If a jury finds you were more at fault than the other driver, meaning your share of the blame is over 50%, you recover nothing. Not a reduced amount, nothing. So the old system was a slope. The new system for car accidents specifically is a cliff. 49% at fault, you still collect a majority of your damages. 51% at fault, you walk away with zero. And this reform didn't come alone. The same law also eliminated the old 90 out of 180 day category that used to let someone qualify as seriously injured just by showing a non-permanent injury kept them from their normal life for most of the 6 months that followed. That category is gone now too. So not only did the fault math get harsher, the bar to even bring a soft tissue claim got higher at the same time. Two changes, same law, both working against the person who got hit. It matters where a number like that 30% even comes from in the first place. It's rarely a courtroom finding. In the early stages, it's usually one adjuster's read of a police report and a phone call where you were still shaken up and talking too much. That preliminary number becomes the opening position in every conversation that follows, and it rarely moves in your favor without a fight. Before this law, if an adjuster wanted to shave down what they owed you, the play was simple. Push your fault percentage up a little. Move you from 20% to 40%, and they've cut your payout in half without ever having to deny the claim outright. It worked. But there was a ceiling on how much they gained by pushing harder, because past a certain point, they were still going to have to pay something. That ceiling is now gone. Now, if an adjuster can push your fault number from 45% to 51%, they don't owe you a reduced settlement. They owe you nothing at all. That 6-point swing is now worth the entire value of your case to them. I call this the 51% Gambit, and it's the single biggest shift in leverage in a New York car accident claim in the last 20 years. This is exactly what happened to a client of mine. I'll call him Danny. His actual fault, if any existed at all, was minimal. He was stopped, waiting to turn when somebody else ran a red light right into him. But the adjuster's first call put him at 30%. When his case didn't settle in the first round, the number on the file crept to 45. That's not an accident. That is a negotiation strategy built entirely around this new 50% line. Push a claimant close enough to that number, and even a good case starts to feel like a coin flip. So if that's the new game, what do you actually do to protect yourself? First, understand that fault gets decided based upon evidence collected at the scene, not on whatever story sounds most convenient to the insurance company weeks later. That means the police report matters enormously. Make sure the responding officer talks to you directly, not just the other driver, and that your account of what happened is actually reflected in that report. On Long Island, that report becomes the foundational document every adjuster and eventually every judge will look at first. Second, photograph everything before a single vehicle moves, if it's safe to do so. Photograph the damage location on both cars. A T-bone strike through a driver's door tells a completely different story than a rear quarter clip, and those angles matter when someone's trying to argue you pulled out early or you had time to stop. Photograph the traffic signal if you can. The skid marks, the position of the debris, all of that either supports your account or contradicts theirs. Third, get witnesses locked in immediately. A pedestrian on the corner of Northern Boulevard who saw the light change. A driver 2 cars back on Sunrise Highway who watched the whole thing unfold. Those people disappear fast. Get a name and a phone number before they walk off. Fourth, and this one trips people up constantly, do not speculate about fault at the scene and do not sign anything or give a recorded statement to the other driver's insurance company without talking to an attorney first. As an EMT, before I set foot in a courtroom, I saw firsthand how people say things in the adrenaline of the moment. They say things like, I didn't even see him. I probably should have stopped sooner. That gets twisted into an admission months later when a case is worth real money. Fifth, get a lawyer involved early, not after the adjuster has already built their fault narrative. Evidence disappears. Traffic camera footage on a lot of these Long Island intersections gets overwritten within days, sometimes even hours. Damage gets repaired and witnesses move. The earlier we get involved in a case like Danny's, the more of that 51% argument we can dismantle before it ever gets in front of a jury. This matters just as much at a chaotic intersection like Hillside Avenue and Springfield Boulevard in Queens as it does out of a 2-lane road in Suffolk County, because the same principle applies everywhere in New York now. Whoever controls the early evidence tends to control where that fault percentage lands. And right now, thanks to this new 50% line, that percentage is worth more than it has ever been worth before. By the time Danny came to us, that adjuster's number had crept to 55%, right on the edge of wiping out his entire claim over a crash he didn't even cause. We pulled the intersection camera footage from a business near Route 110 before it got overwritten, got a supplemental statement from a witness who had already given a statement to police, and we got an accident reconstruction opinion on the impact angle. That 55% fault allegation didn't survive contact with actual evidence. It came down to 15, and Danny recovered the overwhelming majority of what his case was worth. Here's the thing I want you to walk away with. Being partly at fault, or even being accused of being mostly at fault, is not the end of your case in New York. But this new law means the stakes around that fault number are higher than they've ever been. A few percentage points can now be the difference between a real recovery and nothing at all. I'm going to ask you this. If you've been in an accident where the insurance company tried to shift blame onto you that you didn't think was fair, tell me what happened in the comments. I want to know how common this is getting since the law's changed. If you want the full breakdown of everything else that's changed under this new law, including the elimination of 90 out of 180 day category, we cover that in another video on this channel. That's the one to watch next. And if an insurance company is trying to pin fault on you after a New York car accident, Cohen and Jaffe can help you fight that number. Our contact information is in the description.